Zoom here. So, Christine, for 5 minutes, please, your opening statements.
Yeah, thank you for inviting me today. I'm the litigation director with the CCF, which is a legal charity that fights for fundamental freedoms in Canada. And I am fascinated by the question that's been proposed by the committee today, which is the means government should have at its disposal to ensure the exercise of freedom of expression. And frankly, the government does not need more means. The government needs to do less. We already have the right to freedom of expression guaranteed in Section 2B of the Charter. Before the Charter, we had the right to freedom of expression protected in the Constitution Act 1867, which is similar in principle to the United Kingdom, whose unwritten constitution protects the right of public discussion. We are not granted these rights to freedom of expression by our government. We possess them by virtue of being human beings. And throughout human history, it's the government that's the greatest threat to our right to free speech, whether it was the execution of Socrates for his public philosophy or the brutal Star Chamber of King Henry VII, who punished those who printed without a license, or the attempted censorship of New York newsman Peter Zenger for his criticism of the American colonial government. Governments have tried to censor speech that they don't like as long as we have had governments. And it's hard for me to even know where to start on this question. Do I talk about the threat to freedom of the press, the problem with imprisoning people for words alone, the problem with using human rights tribunals to regulate art and comedy, or as Dr. G brought up, how professional regulators are undermining the right of freedom of speech of so many Canadians in those professions. These are all real, live issues today, and the source of the problem is government. On free press, consider the Alberta press case, which involved a law that compelled newspapers to publish government rebuttals to criticism. That case was from 1937, so fears about the so-called fake news or misinformation are not new. But even though the Supreme Court struck down that Alberta law, the silencing of the press continues today. For example, we had the CCF challenge an amendment to the Canadian Elections Act that ended up being struck down in 2019. That was a provision that prohibited the false statements about political candidates during an election period, and it even captured innocent statements and mistakes and had fines up to $50,000 and 5 years in prison. We were successful in having it struck down. And while not censorship in the classic sense, millions of Canadians have lost access to news because of this government's Online News Act, done in the name of saving the news industry. The act has backfired spectacularly, with Meta refusing to comply and blocking news on its platforms. There's the Online Streaming Act brought by this government, which put the CRTC in charge of regulating content from companies like YouTube, Netflix, and Spotify, including user-generated content. And the free press is essential. It's an essential check on the authoritarian impulses of government, and the actions of this government continue to undermine it. On the criminal law power, censorship through criminalizing words is nothing new, even though we're well aware of the problems with it. Consider Quebecois Jehovah's Witness Amy Boucher, who in the 1940s was convicted of seditious libel for accusing the Quebec government of being too close to the Catholic Church. That is a viewpoint that was condemned at the time, but perhaps mainstream today. And consider how expressing the idea that gay people should have equal rights was an unacceptable view 60 years ago, but thanks to the free speech of people who publicly advocated for change, we have equal rights now in Canada for the LGBTQ community. Free speech is important for those who are in minorities, whether they're a minority viewpoint or a minority in some immutable characteristic. Free speech is how we define the contours of our other rights. It is not a value for the right or the left. It is a nonpartisan right for all Canadians, yet this government continues to undermine it. One of the purposes of free expression is to allow for debate on even the most controversial topics, because vigorous debate is how we best settle our disagreements, including disagreements about who should lead government. Free debate on contentious issues can't happen if the people currently in government are allowed to outlaw opposing point of views. The right to express your words and ideas goes to the core of who we are as individuals. The government doesn't need more means. It needs to stop trying to silence speech.
Thank you very much. Right on time. Mr. Giovanni, please.
Thank you, Mr. Chair. Well, certainly this is a very important topic, and I appreciate the witnesses for being here. I do have some questions for Ms. Van Geyn, who I think gave an excellent set of opening remarks. And Ms. Van Geyn, I'd like to speak with you in particular about Justin Trudeau's censorship agenda, which has been implemented by the Liberal Party, certainly with help from the NDP. And when we talk about the censorship agenda, we're talking about primarily two pieces of legislation, Bill C-11 and C-18. Ms. Van Geyn, I'm sure you're familiar with them, but just for the sake of being on the same page, Bill C-11, of course, refers to the Prime Minister, Justin Trudeau, and the federal bureaucracy gaining more control over what Canadians can access on streaming platforms online. Bill C-18, of course, refers to Justin Trudeau and the federal bureaucracy having more control over the news that Canadians can see, which is limited access that Canadians have to news on platforms like Facebook and Instagram. So I'd like to start with just asking Ms. Van Geyn, do you share the concerns of many Canadians who are worried about Justin Trudeau's censorship agenda and Bill C-11 and C-18?
I would add to that list Bill C-63, which has the potential to be one of the most censorious pieces of legislation that I've seen in a really long time. C-63, the Online Harms Act, would increase penalties for criminalized speech and hate-motivated crimes to life in prison, which part of the concern around that is using these heightened penalties to overcharge criminal defendants and create pressure for plea deals for lower level offenses when there is an argument that the Crown might make that there is a hate element. Even if it's not present, it can be charged, and this overcharging leads to pressure to plead out. Another concern we have about C-63 is that it would allow for someone who fears a future hate crime speech, that they can request a judge to put conditions on the would-be speaker, things like an ankle monitor or even imprisonment. And this is for future speech that has not yet taken place. This is incredibly chilling. C-63 would also create a civil mechanism for people to complain about speech to the Human Rights Commission. It's a return of Section 13 of the Canada Human Rights Act, which was rightly repealed for dragging before the Commission journalists and members of the clergy. There is no cost to bringing a complaint, but there's great cost to the complained about. And we have seen human rights tribunals bring claims, bring before them comedians. That's in a Quebec context. So giving this power to these commissions will chill expression. I did not have time in my 5 minutes to mention C-63, and I understand that there is a separate committee hearing that will address that, but I wanted to put on the record our serious concern about that. With respect to the Online News Act and the Online Streaming Act, while perhaps not censorship in the most classic form, I do share the concerns of millions of Canadians who have lost access to news as a result of the Online News Act. I share the concerns of a lot of academics and Canadian content creators about the regulation of user-generated content on social media platforms like YouTube. I'm a YouTube creator myself. I have one of the largest, I think probably the largest YouTube channel about Canadian constitutional law, perhaps niche.
If I could just ask
and it will censor that.
Ms. Van Geyn, if I could just ask a follow-up to that, because the Trudeau Liberals very much like to misrepresent their censorship agenda as being solely focused on big corporations. But as you noted, it does include...
Mr. Chair, well, I do want to hear Mr. Giovanni's question. He's making an assertion as to what our intention is, which I think is, you have ruled before,
Well, you
is
didn't
not
let me finish
reasonable.
the question, so you're getting ahead of yourself.
Didn't even need to get
I know
there.
you're
You
an
already
eager
said
guy.
it.
I know you're an eager guy. So if I could just ask the question to Ms. Van Geyn, you mentioned that user-generated content is included in Justin Trudeau's censorship agenda, which law professor Michael Geist has detailed in a series of blogs explaining that it is not just a matter of focusing on corporations. What is the importance of this censorship agenda, including user-generated content?
A short answer of 20 seconds, please.
The effect is that it puts the government putting its thumb on the scale of what content Canadians see, and that in itself is inherently censorious.
Okay, thank you very much, Ms. Van Geyn, and Mr. Giovanni will move 4 minutes.
Thank you very much, Mr. Chair, and appreciate our witnesses being here, although I do find it astounding that that the NDP and Dr. Guy just suggested that for somehow the leader of the opposition was guilty of a criminal offense for standing up for Jews having the right to their own state. I would, however, Ms. Van Geyn, Bill C-11.
Point of order.
Point of order, Ms. Ashton.
Yeah, I think we need to be accurate. Nobody said such a thing. And the quote that I shared was with respect to Israel's bombing. Let the record show exactly what was said rather than conservative interpretations.
Okay, move on. Mr. Couric, please.
Canadians can judge for themselves. Ms. Van Geyn, when it comes to Bill C-11, do you see it in conflict with the basic freedoms that Canadians are guaranteed in the Charter of Rights and Freedoms?
I do. I do have issues with C-11. In particular, the ability of the CRTC to regulate user-generated content. That, I think, is the biggest concern. The analogy that a lot of us who are online content creators, Canadians, have given is if a bookstore is ordered by the government to put certain books in the window and certain books at the back, would we view that as a censorious government act? And that is the analogy that a lot of us in that ecosystem have been using related to what the C-11 CRTC power to put its thumb on the algorithm is doing.
If I could, just because time is so short, it's been described largely as backdoor censorship. The Justin Trudeau and the Liberal censorship agenda. They're not telling people that they can't believe something, but they're restricting through technological means, algorithms, the content that's available. Would you agree with that?
Yeah, I think that you could describe it as backdoor censorship. It's not censorship in the classic form, but it's a big problem.
Yeah. Thank you for that. And now I'm curious about C-18. Again, do you see C-18 as being in conflict with the Charter of Rights and Freedoms and the freedoms guaranteed for Canadians in it?
So it kind of depends on how the regulations are going to be interpreted with respect to the Online News Act. I think that it's not censorship in the classic form that we think of, but depending on how it's operationalized, there could be a charter case to be made against that particular piece of legislation.
Did you find it deeply problematic, or did you find it problematic that that as a result of C-18, news content basically on some of the most used social media apps in the country was eliminated, restricting Canadians' ability to see what was happening in the world?
Yes. I mean, this was in direct response to government action. Meta took the action of blocking news on Canadian versions of their platforms, including Facebook and Instagram, and millions of Canadians were accessing news that way. It actually undermines the ability of the free press to function because of the loss of clicks, which is how some of their revenue was being generated. Sharing news is not a threat to the news industry.
So we have Bill C-11, Bill C-18. I know you mentioned as well Bill C-63, direct threats to Canadians and the freedoms that Canadians are guaranteed through the Charter of Rights and Freedoms. That certainly seems like a censorship agenda to me that needs to be fought against. Thank you very much to the witnesses for coming today.
Thank you, Mr. Couric.